Thank you. Good afternoon. My name is David Koplow. I'm a professor at the Georgetown Law School, and it's my pleasant challenge this afternoon to offer you a full semester course in public international law in 15 minutes, including leaving time for Q&A. In order to accomplish that, let me dive into three particular concepts, three terms that sound similar but have very different legal consequences. And those are liability, responsibility, and accountability. I need to explain that the vocabulary here is somewhat inconsistently applied. You'll see different expressions, different definitions in the literature, but it is important to try to tease them out because for planetary defense, they have very different legal consequences, and some or all of them could be implicated in any particular planetary defense scenario. I should also say at the outset that the work underlying this presentation has been draws upon the work of the ad hoc legal working group established by SamePage a few years ago that you've already heard about, the group that was designed to provide SamePage with independent expert legal advice. Many of the participants who underpin this presentation also participated in that working group. So first, let me give you the background, the introduction to liability and responsibility, related but different terms. Responsibility arises when there has been a breach of an international legal obligation, when a country violates a treaty. That is a wrongful act. The first rule of international law is that promises are to be kept. Countries are supposed to abide by their legal obligations. When you violate a treaty, that is presumably wrongful. Countries are not allowed to plan to do that. When you do violate a treaty, you're supposed to stop doing that and not continue the violation. And under some circumstances, there's a responsibility to pay compensation to a country that's been injured by your illegal act. But it's important to note that responsibility can arise even without an obligation to pay compensation. That's a separate concept under international law. There can be responsibility for a treaty violation that does not incur an obligation to pay compensation, where no particular country or no other actor has been injured by your illegal act. It's also worth noting, I'll get to this point a bit more further in just a moment, that there are excuses for a violation of a treaty. There are some circumstances where a treaty breach, whether it's the Outer Space Treaty, the Limited Test Ban Treaty, or any other, where the violation may nonetheless be excused even though it has contravened the treaty obligation. That's responsibility. Liability is about the requirement to pay compensation, where you've injured another state or another corporation or person by your international actions, you may owe a duty to pay compensation. And ordinarily in international law, as in domestic law in most countries, the requirement to pay compensation, your liability to pay, is built upon your having undertaken a wrongful act, a deliberate act or a negligent act or something of that sort. But international law on space is somewhat different. And as I'll describe in further detail in just a moment, there are some circumstances where you may be obligated, you may be liable to pay compensation even if you have not behaved in a wrongful fashion. Nonetheless, you may have to pay compensation. So the two concepts of liability and responsibility are linked in that way. Responsibility is a wrongful act that may not involve a requirement to pay compensation. Liability is a situation where you have to pay compensation even though your action may not have been wrongful. And I'll explain that a little bit further in just a moment. The next concept here is accountability or national action. And that's the question about what state, if any, is responsible, is accountable, is attributable for the actions in outer space. And here again, space law is a little different. Ordinarily, a country is responsible for its own actions. Anything that's undertaken by the country, by its agencies or instrumentalities, the state is accountable for those actions. But ordinarily, a state is not accountable under international law for actions undertaken by its corporations or its private persons. If you are harmed in some international setting by a foreign corporation or person, you can pursue them, but ordinarily not the state of their nationality. International law in space is different in that regard. Article 6 of the Outer Space Treaty requires that a country is accountable for the actions of its own government agencies, but also accountable for the actions of its private persons or corporations. That's an unusual rule, and it makes, and Article 6 also requires that a state is responsible for authorizing and supervising the activities of its private persons and private corporations. That means that the actions of a corporation or of a private person will ordinarily be attributable to a particular state or more than one state, all of which can be accountable under international law. In addition, the Liability Convention ascribes accountability to the launching state, and the launching state is defined in pretty broad terms under that treaty. Requires a launching state is a state that launches or procures the launching of a satellite. It's also a state that whose territory or facility is used for undertaking a space activity. And therefore, again, there could be multiple states that count as the launching state, multiple states that have that are accountable for the behaviors of that space mission. Let me talk a little bit further about liability. As I said, liability emerges when there is a requirement to pay compensation, and international law has a remarkable and unusual two-tier structure for liability, depending on the location, the place where the harm occurred. Under Article 3, if the harm occurs in outer space, your satellite collides with another satellite, you are liable, you have to pay compensation if you have been at fault in that activity. Fault is a term that's not defined under the treaty. It's not well worked out in the rest of international law. Perhaps it means something like negligence, but it's in contrast to Article 2, which provides a very different kind of liability regime, where if the harm occurs on the surface of the Earth or to aircraft in flight, there is absolute liability. You're required to pay compensation, even if you have done nothing wrong, even if you've behaved according to the highest standards of technical capability, behaving in good faith. Nonetheless, the concept is that space activities are hazardous or ultra hazardous, and therefore the harm should not fall on an innocent bystander. If damage is inflicted on the surface of the Earth, the country responsible for doing that activity is liable, even if they have not behaved in any negligent or wrongful fashion. That's liability. I said that under responsibility, a state is accountable for the actions that it has undertaken or that's undertaken by its nationals, and that if you violate an international legal obligation, a treaty or any other international legal obligation, the state is responsible for that bad behavior. There are, however, certain circumstances that count as excuses for non-compliance with the international legal obligation, and three of them may be of particular relevance to a planetary defense mission. The first is consent. Any state can waive its ability to hold a state accountable for its wrongful action by requesting the activity, by participating in the activity, by supporting the activity. That consent, of course, is given on a state-by-state basis. No one state can waive the responsibility with respect to another state, and therefore it would matter if you could get multiple states to provide their consent to the activity. That would mitigate the responsibility regime for the states that undertook the mission. The next two, distress and necessity, are linked. They can provide an escape hatch, a circumstance that precludes the wrongfulness of the space activity. But these criteria are defined narrowly and applied strictly, as you can see. It applies if there is no other reasonable way to save human lives or to safeguard another important state interest against a grave and imminent peril and does not seriously impair the interests of other states. As I said, that's defined narrowly. The bottom line on this is that there could be many circumstances where the liability and responsibility regime could impose a significant deterrence on a state contemplating undertaking a mission. Even if it behaves in a reasonable fashion, it may nonetheless be accountable if the mission has been what you might call partially successful. If it has succeeded in deflecting the trajectory of the asteroid somewhat, but not succeeded in deflecting it enough to miss the Earth altogether, the asteroid would then impact on the Earth at a different location from where it would have impacted if there'd been no space mission undertaken. The place where it's located, where the impact has occurred, has therefore incurred damage that would be attributable to the state. And the fact that the state has behaved in a reasonable fashion would not be a sufficient excuse from the liability regime. I see my time is up. If you've got questions, I'd be happy to address that. Oh, I have 3 minutes. Okay. Well, then let me proceed quickly to identify the team that has been participating in this. As you can see, there's an all-star group, and the slides give you the contact information for all of them. And we'd be happy to address any further questions you might have at this time or subsequently.
Thank you. Questions? You have to have questions.
We should also note that this is getting close to the exam period at most universities. And so if you don't have questions, I'll have some for you and then give you a quiz and a grade on the. Chris.
Hi, thank you for your presentation. Chris Johnson from the Secure World Foundation. I want to revisit a question that was given in the last presentation, the differences between nuclear weapons, nuclear explosive devices. Is it permissible under international law to use a nuclear explosive device as a response to asteroid threat?
Good. So this is a subject that the ad hoc legal working group advising Same Page had spent some time addressing. And our conclusion, which I support, is that a nuclear weapon is a nuclear explosive device is a nuclear weapon, and that the Outer Space Treaty would prohibit the use of a nuclear explosive device for a planetary defense purpose. There may nonetheless be circumstances that preclude the wrongfulness that make it legitimate for a state to violate the treaty obligation. Necessity and distress, those circumstances are applied very narrowly. There are some other treaties that treat nuclear weapons differently from nuclear explosions for peaceful purposes. The Outer Space Treaty does not.
Jan Osbrook with RAND. So a related question, since, I guess there is a certain consensus among the technical community that, nuclear explosive device should at least be one of the tools in the quiver for certain, extreme scenarios. What would be your suggestion to deal with the legal situation? Change those treaties or amend those treaties, or have a new, treaty or Security Council decision that can override those treaties for certain situations, or go with the, it's better to ask for forgiveness than request permission approach?
So again, the legal working group had to deal with that. There are a number of remedies, at least possibly available, such as amending the treaty, withdrawing from the treaty, something of that sort. But the path that we prefer is a Security Council resolution. The United Nations Security Council has an extraordinary authority under the UN Charter to make new law, including superseding the provisions of existing treaties. And a Chapter 7 resolution adopted by the Security Council, we think, would be the securest method for doing that.
And would now, before there is a specific threat, so that all nations are kind of threatened equally, be a good time to launch that sort of effort, or wait until there's something concrete that requires action, but then there might be some politicking about who would be damaged more, and maybe just veto it too.
So it's possible that the Security Council would have to be activated on multiple occasions. First, at a preliminary stage such as now, to anticipate the circumstance, what's actually required, whether, for example, a nuclear explosive device or multiple nuclear explosive devices or one or more countries would be required to participate in the mission.
Thank you.
Brent, hold on, there was a question in the back. There's a question in the back.
I think he was standing up there for me.
All right, Brent.
Okay. So you actually answered some of my questions just now, but I will express the opinion that this lack of distinction between a peaceful versus non-peaceful detonation of a device in space is outdated and frankly no longer applicable. I mean, we have to consider the fact that multiple decades have passed since that was conceived, and now we have a modern reality where planetary defense is a field that's developed, it's understood, and it brings new realities to the table that have to be reckoned with. So I'm very glad to hear in your response to the previous question that appropriate measures are being undertaken to provide for amendments and new resolutions that would appropriately treat this problem instead of just blindly applying old language that actually has nothing to do with planetary defense?
Well, remember the reason why the Outer Space Treaty, and for that matter, the Limited Test Ban Treaty and the others, treat the two different kinds of devices the same, is because the purpose of the Outer Space Treaty, or for the Outer Space Treaty, was not designed to deal with anything like the asteroid threat. The purpose was to prevent a nuclear arms race in space.
Precisely.
And the physical reality is that a nuclear explosive device that we used for an anti-asteroid mission is nearly indistinguishable from the kind of nuclear explosive device that would be used for warlike purposes. And therefore, if a country is given permission to do one, it automatically has the capability for doing the other. That's why the treaty drafters prohibited all of them, because they could not differentiate. And that's been the general strategy of nuclear arms control across the board.
Sure, which makes sense. And all I'm saying is that now, in view of modern planetary defense realities, it's an appropriate time to revisit that and create a framework that is more conducive to what needs to happen in the future.
But the trick is to do that in a way that does not undercut the nuclear arms control regime.
Sure, absolutely.
Is your question the short one?
The question is short. I don't know if the answer will be.
Okay, we'll take that.
Touche.
So I guess how does like a high altitude nuclear detonation fall within the context of all this? Because, one of the ways that you can use it for non-peaceful purposes is, you detonate it at 600-700 kilometers in altitude, get that EMP effect on the ground. But that seems like we accept that, like that's something that people can do in a wartime, but that's clearly goes against the language that's in the treaty, right?
So there's two treaties that are relevant, and I will be brief. The Limited Test Ban Treaty prohibits nuclear explosions in the atmosphere and in outer space without drawing a distinction as between them. And therefore, the height of burst would not matter. The Outer Space Treaty deals with nuclear weapons being placed in space, and that treaty and the rest of the corpus of international space law does not draw a distinction between space and atmosphere, and therefore it's ambiguous in that regard.
Let's thank our speaker.
Thank you.